Law Review on 107.3 FM and AM 580, Orlando's news and talk. Remember, the answers given on this show do not constitute legal advice and do not create an attorney-client relationship. For that legal advice, you can call the office anytime at 1-800-DeWitt Law or just interact with the show by sending us an email to ask@DeWittLaw.com. That's ask@DeWittLaw.com, or you can also call and leave a voicemail too if that's easier, 407-53 Moses. Every Sunday morning at 10 a.m., you'll learn how Florida's legal issues affect you with your host, Mo DeWitt of the DeWitt Law Firm. Mo will answer your questions to discuss the latest legal issues affecting the citizens of Central Florida. Good morning, Mo. Welcome back to another edition.
Good morning, Jay. How are you doing?
I'm fantastic. So let's talk for a moment about this Tiger Woods lawsuit that you kind of brought a little bit to my attention. And I'm like, no, I haven't heard about it. But wait, what?
Yeah, surprisingly, I really haven't heard much in the media about it lately, but it's been somewhat publicized where Tiger Woods is involved in some legal trouble, I guess you could say, once again. Obviously, he got into some trouble a number of years ago. Mm-hmm. And this time, his girlfriend of 6 years, who lived, I guess they lived together down in South Florida somewhere, I think maybe it was Jupiter or something like that, is suing him for $30 million. And
it's a lot of money.
It's a lot of money. Now, Tiger learned from his legal troubles years ago, hey, I need more non-disclosure and confidentiality agreements in my life.
Okay.
So as part of this relationship, at some point in the relationship, Tiger had his girlfriend sign an NDA, a non-disclosure agreement.
And that basically says what? You can't go around telling everybody that we're dating, that type of thing?
Well, I'm sure there's terms on it. Now, they probably could say that they were dating, but there's probably terms that they said, no details of the relationship. If I had to guess, given what he went through before, probably no details regarding sexual intimacy and things like that.
Right.
I would guess there's probably a number of different provisions in there that basically prevent her from speaking about the relationship beyond just saying, yeah, we're in a relationship.
Protect his celebrity.
Yeah. Now, the thing about NDAs is typically you pay for an NDA one way or another. So, even when we settle a case, if there's a confidentiality agreement involved in that case, mm-hmm. we assign a separate amount of money to that confidentiality provision. I think we talked about this case before. There was a famous case that kind of started all this with Dennis Rodman, where he, when he was playing basketball, slid in or hit a photographer. I forget exactly how it happened. Mm-hmm. And, basically there was an issue with taxes as far as how much of the settlement was for, injuries and lost wages and how much was for the confidentiality. So you always have to assign a number essentially to the confidentiality. So most likely she was paid some amount of money. Now, they were dating. Maybe it was $1, maybe it was $100,000. Right. We don't know. But she has now moved or filed a lawsuit rather, and moved to ask for this NDA to be overturned, essentially. And the way she's doing that is under this Speak Out Act, which was passed, I think, in 2021. It's a federal act that was passed fairly recently. Mm-hmm. And so what it basically does is say, if you're a victim of sexual harassment or sexual assault, you can have an NDA overturned. And so his girlfriend has filed a case, I think it's down in Martin County, Florida, asking for this NDA to be overturned.
Based on one of those two things?
Based on one of those two things, yeah. I mean, so the funny thing is she filed the complaint the first time. She filed the lawsuit the first time mm-hmm. and forgot to include that.
Oh.
Tiger Woods' attorneys, and I should say, it's technically a trust that Tiger Woods is the beneficiary of because the home was in a trust. But
okay.
For all intents and purposes, it's Tiger Woods. Mm-hmm. His attorney moved to dismiss it. Then they amended the complaint and said, oh, wait, we forgot. We have to add those provisions alleging sexual assault or sexual harassment. Now they've alleged it. They haven't really given any details as to what that is.
Right.
But they're not suing. They're not asking for the $30 million for the sexual assault or sexual harassment. They're asking for it because they're saying that the girlfriend of Tiger Woods had an oral tenancy, basically an oral contract mm-hmm. stating that she was allowed to live in this mansion in South Florida for 11 years. And so the loss of the use of her not being allowed to live in the mansion, Tiger Woods has to pay her $30 million. That is their claim.
Because they broke up.
because they broke up. And there is a bit of a salacious story about how they broke up too, and we can get to that too if you want.
Is it so this just sounds like, and granted, it sounds like bitter girlfriend syndrome. Is that what basically? I thought I was going to be set for 11 years. We broke up, and now I want something out of this.
Well, I don't know where they get the 11 years from. I mean, that's kind of a random number. It's not 9, it's not 10, it's 11. They've only been dating for 6 years. I mean, it seems a little, pulled out of thin air here.
Right.
So I don't know where they get that number exactly, but I mean, it does feel like a money grab. I mean, it doesn't feel like it looks like
that's
a money
what it looks
grab
like on paper.
completely,
Yeah.
Maybe there's more to it behind the scenes that we don't know of, but it looks like, hey, I was dating a millionaire, pay me some money, I thought I was set here, so on and so forth. Now,
is that maybe too like we go for 30 and we'll just give you 3 and they know that and they go away?
Well, it could be,
I guess.
It could be. So, Obviously, it's pretty well known that Tiger Woods settled a lot of these lawsuits with these other women.
Yeah.
I don't know if that was 10 years ago at this point or 15 years, however long ago it was.
Mm-hmm.
So there could be a mentality, hey, he's settled these kinds of cases before. Maybe we'll get a quick settlement from him as well. So that could be what they're hoping for. Now, from a legal perspective, there's a number of things wrong with this where, in Florida, if you have a lease agreement for, a residential piece of property, typically, especially for 11 years, it can't be an oral contract. It has to be in writing. Anything oral is typically going to be a month-to-month tenancy,
right,
and fall under the statute that way. So it's barred, in my opinion at least. It's barred by what we know as the statute of frauds. Basically, it doesn't deal with fraud as in the normal term, but it basically says, hey, this has to be in writing, otherwise it's not enforceable. So I don't know how they plan on getting around that. I mean, that's something that's basically on the bar exam. You're taught in the kind of first-year law school. It doesn't seem like they've done a great job here, putting together any sort of valid complaint, especially since they left out the allegations in the first place. The other kind of weird thing about the Speak Out law, and obviously, the intent behind it is good, but when you read that initially, you think, okay, well, if the NDA is going to be set aside for sexual harassment or sexual assault, they must be suing for those things, right?
Right.
I mean, that's what at least popped into my mind. Okay, that makes sense. You're going to set aside the NDA because there was sexual harassment, sexual assault. Then you're going to file a lawsuit for one of those two things. But here they're completely unrelated. It's just that's an avenue if you make those allegations to get the NDA overturned. And since this is such a new area of law, it'll be interesting to see what level of proof do you have to provide. Theoretically, you shouldn't just be able to make the allegations. You have to substantiate them somehow. So what is the burden of proof on the person bringing the claim to invalidate the NDA? They brought what's called a declaratory judgment action. Basically, they're asking the court to define their rights here as to whether they can invalidate the NDA and then speak further, essentially. But what is the level of proof there under this federal act to invalidate that? Given that this act is fairly new, it's only a couple years old at this point, there could be some case law made on that as far as what kind of allegations need to be made in order to invalidate NDAs. Now, typically courts, don't really want to overturn a non-disclosure or confidentiality agreement for public policy purposes.
Right.
And like I said, when you get one of those, typically usually pay for it one way or another. It's part of a contract. It's negotiated for. It's usually not something that's just kind of slipped in there on the fine print. It's usually bartered for. There's a conversation about it. It's included as part of the release that you sign or whatever it may be. So usually courts want to uphold those kinds of contracts where two people entered into them, freely, voluntarily, willingly, and with full knowledge. And I would assume, Tiger Woods, I'm sure, has pretty good attorneys and pretty smart attorneys at this point. I would assume, they probably, gave her money to go have an attorney review the non-disclosure agreement, sit down with her, explain it to her, define her rights. And that's probably why she's not making other claims such as, she signed it under duress or didn't know what she was signing. Not that those would necessarily hold up either. But typically when you see someone try to get out of an agreement, they're usually kind of alleging coercion, duress, fraud, things along those lines. Here they're operating under this federal Speak Out Act, which will be interesting to see what happens with it. But ultimately, it's a pretty interesting lawsuit and pretty salacious all around. I'm sure Tiger Woods is happy it hasn't been in the media more.
Right.
But, and we didn't talk about how they actually broke up. That's almost
boy.
That's part
the
of the
meat and
story
potatoes
here.
of it. All right.
Yeah. So, basically, the girlfriend's attorney said that she was just kicked out on the street. Tiger Woods' attorneys came back and responded and said, not exactly. One of Tiger Woods' people basically approached her, said, hey, you're taking a short vacation, pack a bag. They drove her to the airport and basically told her, hey, you're not allowed back in the house, put her up in a luxury hotel, and basically gave her some spending money to get her back on her feet is what they're saying.
Because if you're living there for a certain amount of time, you can't just kick somebody out, right? Don't you have to give them like 30 days or something like that?
Typically, yeah. Typically, like I said, it would be a month-to-month tenancy.
Right.
So then you have to give 30 days notice if that was her primary residence, which I would guess it would be. So maybe there's a small amount of damages for that 30-day window.
Mm-hmm. But she's in a luxury hotel with spending cash. She's doing all right.
Yeah. I mean, I'm sure you've been broken up with many times, and they drive you to the airport, put you up in a luxury hotel, and give you some spending cash.
Absolutely,
I mean, that's just the way it goes. That's part of life.
Let my crushed heart heal.
Exactly. So, obviously, I think when you look at this as a whole, and again, I always say that maybe there's more of the story than we know, right?
Yeah.
Because we only know what's out there in the media, what's been put out there by the attorneys at this point. But really, this does look like a money grab at this point in time. If Tiger Woods again settles it, then maybe down the road more people come out and say, hey, you owe me money for X, Y, or Z.
Right.
A lot of times there's just a cost of doing business where you look, okay, what's going to be the cost of litigating this versus the cost of settling it? Mm-hmm. I can tell you the cost of litigating it's far south of $30 million.
Right.
So and what how are you even alleging $30 million? I mean, that's just
where does that number
so
come from?
Absurd to me. In the 11 years, I mean, the whole thing just doesn't make any sense, frankly.
Right.
But again, maybe there's more to it. But it'll be interesting, as far as that federal act goes. That's probably one of the first cases, certainly the first highly publicized case that we've seen where someone tries to get out of a non-disclosure agreement based on this federal act. I'm not sure if you went back and looked at the statutory intent of this act when Congress essentially created it, because it is a federal act, if this is what they really intended it to be used for. I think the actual statutory intent probably went more towards things like what Bill Cosby was accused of and things of that nature. So where he settled a lot of those claims, had people sign NDAs. I think the courts there would, of course, say those probably are not valid under this Speak Out Act if it happened afterwards. Right. I don't think that the act is retroactive.
Which makes sense, and it's a good thing, to be for people to be able to come forward and say these things.
Right. The disconnect to me, and maybe I'm wrong, and you can always give us a call and let us know your thoughts. But the disconnect to me is that the allegation that they're alleging under the Speak Out Act and the allegation of why they're owed money are not correlated in any way.
Gotcha.
And that's where I think, the act is maybe didn't contemplate this, or maybe it did contemplate this and it's just overly broad. But certainly, I don't think that was the original intent of the act when you're looking at it and when you're looking at the class of people it was designed to protect.
It'll be interesting to see. Now you've got my attention watching something else. First it was the Murdoch trials, and now it's this. Now it's Tiger Woods' case.
Well, I had to come up with something besides Murdoch.
Yeah,
I would talk about Murdoch for the next years, and people would be like, wasn't that trial over like a year ago, Mo? Come on, move on.
But it's still interesting, and now this is too. This will be very interesting. Man, it's got to be tough to just live in that lifestyle, just knowing that at any moment, any left turn, right turn, somebody's just going to be out, for your celebrity, and just because you've got deep wallets, just to be able to come after you. So we will wait and see. All right. You are listening to the DeWitt Law Review, and we're going to get to your questions coming up here in just a minute. If you've got one and you want to send a comment, or whether it's about the Tiger Woods thing or you got something going on in your life, you can send an email directly to Mo. It'll go to ask@DeWittLaw.com. Ask@DeWittLaw.com. You can also call and leave that voicemail if that's easier. 407-53-MOSES. 407-53-MOSES. Also, you can check them out online, DeWittLaw.com. And if you just need some legal advice, something that maybe doesn't tie into the show here, but you do need to get some legal advice, you can call the office anytime over at the DeWitt Law Firm. That phone number is 1-800-DeWitt-Law. 1-800-DeWitt Law. We will get to your questions here coming up in just a moment. You are listening to the DeWitt Law Review on 107.3 FM and AM 580, Orlando's News and Talk.
All right, the crash happened. I was at a stop. The car was coming in, rear-ended me from behind. I was trying to get out of the way, but yeah, that didn't happen. Yeah. After the crash, I just kind of sat down for a couple minutes, gathered my thoughts, after the ambulance and stuff. Got discharged, went home. I was really trying to think about what to do next because, that was my first accident. Of course, you hear all the time, call an attorney, so I wasn't really sure what route. I reached out to a friend of mine and she was just like, hey, I have someone you can reach out to. And she said, just call Mo.
Many of our clients are referred to us by friends and family, just like in Jamal's case. It was an honor to be able to represent him and ultimately fight to get him the compensation that he deserved.
My experience with Mo was really good. His team, his staff, very informative. I received all the information I needed, step by step. They made sure I was satisfied with everything, and everything has been really good. They're very detailed. They're very, they call or text whenever they make a move or whatever they're doing. They're mailing out a letter, anything. I'm always in the know. So that's really good on their part. So yeah, if a friend or family member, anyone would ever ask me if they need an attorney, I'll always say, just call Mo.
Welcome back to the DeWitt Law Review on 107.3 FM and AM 580, Orlando's News and Talk. My name is Jay Edwards, here with your host, Mo DeWitt of the DeWitt Law Firm. If you've got a question, we want to give you some advice. Well, not me. Mo will give you the advice. Ask@DeWittLaw.com is where you can send that email or also leave a voicemail at 407-53-MOSES. We'll get to your question. Mo will give you some advice. Mo, let's go ahead and jump in and get to some of our questions here.
Absolutely.
Mo, can management threaten write-ups regarding uniform while letting their favorite, quote-unquote, favorite employees slide daily? This person says, 2 of us wear our uniform properly, 3 don't. The 2 of us, if one thing is out of place, we hear it for days, yet the other 3 don't button their vest. They wear a hat while working, sleeves rolled up. We were told that 2 of us had to be rolled down sleeves because of our tattoos, but for the first 8 months, that wasn't the case under a new favorite employee comment, made a comment. Now they've added a tie to our uniform, which is fine, but again, the 2 of us are the only 2 that we're told that we have to wear one.
So as we talked about before, Florida is an at-will employment state. Basically, they can fire you for any reason as long as it's not discriminatory, as long as it's not a protected class. So if you're wearing a purple shirt one day, they say, I don't like that purple shirt, get out of here. They can fire you for that. Now, typically this is what we would call arbitrary and capricious enforcement, meaning that you're selectively enforcing, the rules against certain people. And, when we have claims of, dealing with homeowners associations or condominium associations, oftentimes that is a defense to it, is that, hey, you're only enforcing the rules against one person, not everybody.
Gotcha.
But when it comes to an at-will employment situation in the workforce, like I said, they can fire you for any reason. However, if they're basically saying that you're not complying with the uniform requirements, but really they're discriminating against you for a reason that is protected by a specific class, then you may have a cause of action there. So that's where you kind of have to unravel what's actually going on versus what they're saying is going on. And so if they're just harder on you because, your sexual orientation, gender, race, whatever it may be, whatever is a protected class, then you may have a discrimination lawsuit against them. But of course, you would have to show that it was actually based on the discrimination and that you just weren't following the rules. If you're the only one not following the rules and you get written up for it, not much you can do. If there's a number of, if it is truly arbitrary and capricious enforcement, selective enforcement, then you may have a cause of action there.
And I mean, I can see any boss if they decide, hey, that's fine, I don't mind the tattoos. And then after 6 or 8 months, customers complained, or you just realize that maybe that's not a good look for our business. And you're like, all right, sleeves rolled down now. As a manager, you can change your mind anytime. I mean, you've got an image to uphold for your company.
I mean, that is the thing. You can always change your mind. You can always change the rules. You just got to tell people about it, of course, but you can change whatever you want to do.
Right.
You can change the uniform completely. You can make them wear tuxedos to work if you want to.
Please do that. I'm sorry to the person that wrote that in, but I guess you just got to pick and choose your battles.
If my AC repairman shows up in a tuxedo next time, I'll know why.
You'll know he's listening to the show.
I'll know exactly why. But yeah, I mean, they can change the rules. They can change their minds about things. Ultimately, it's their business, or they're the manager for the business, and they have the discretion to do that.
Okay, very good. Hopefully that answers your question. Mo, can you tell us real quick? We got about a minute left, but I want to touch on the book real quick in case anybody's going through any type of divorce right now or thinking about it. I know you've got a fantastic book that can really help out.
Yeah, absolutely. So you can get the book. It's called DeWitt's Guide to Divorce. You can get it at DeWittDivorce.com. There's a free copy there to download. It's also available on Amazon and Audible. I think you do have to purchase it there, but for WDBO listeners, we are giving away for free at DeWittDivorce.com. And basically, it's a guide that kind of walks you through the process of divorce. A beginner's guide, so to speak. Mm-hmm. It's not going to give you every detail, but it gives you the information to know what to expect so that you can be prepared if you are going through a divorce, if you're thinking about going through a divorce, or if you have a friend or family member who might be going through a divorce. Because one of the things that I find with people who are going through that situation is it's just tough to know where to turn for advice.
Right. Perfect. Very good. All right. Well, that's where you can get your hands on it. And if you've got some questions here, whether it's about divorce, whether it's about wearing your uniform to work, whatever it is, we can help out. Not we, again. Let me reiterate that. I'm just the guy over here pushing buttons, introducing the man with the advice, Mo DeWitt of the DeWitt Law Firm. So send those questions in. ask@DeWittLaw.com. You can leave a voicemail 407-53-MOSES. And also call the office anytime if you do need some legal advice. 1-800-DeWitt-LAW or online DeWittLaw.com. We'll be back. More questions, more advice. It's the DeWitt Law Review on 107.3 FM and AM 580, Orlando's News and Talk.
When you get hurt on the go, you got to call Mo, right? I was walking across the parking lot, and my ankle rolled, and I tripped, and broke 4 bones and tore ligaments in my ankle. Oh, my experience with you guys were great. You guys were awesome. You took care of all of my needs. You really put my mind at ease, and I felt really taken care of by you guys. I would definitely recommend Mo if anyone got injured on the go. I would definitely recommend Mo.
Welcome back to the DeWitt Law Review on 107.3 FM and AM 580, Orlando's News and Talk. Remember, the answers given on this show do not constitute legal advice and do not create an attorney-client relationship. For that legal advice, you can call the DeWitt Law Firm anytime at 1-800-DeWitt-LAW. That's 1-800-DeWitt-LAW. Check them out online, DeWittLaw.com, or you can always ask your questions here. We'll get them out on the air. Mo will give you some advice. Send those questions to ask@DeWittLaw.com, or you can call and leave a voicemail 407-53-MOSES. My name is Jay Edwards here with Mo DeWitt of the DeWitt Law Firm. Let's go ahead and get to some more of your questions and some of your answers. All right, here we go, Mo. I got a whole stack of them here. My ex-wife, after 17 years, has filed a request for a financial affidavit. I've been paying an agreed amount of $150 a month for the last 5 years, which she had agreed verbally. I owe back alimony. Now she wants money because my father passed away in January and I inherited some money. If I don't respond back to this affidavit form, what are the possible ramifications of this action? Thank you in advance for your answer.
So first of all, in Florida at least, unless there is a lawsuit pending or an active case, I should say, you have no obligation to fill out a financial affidavit. In some other states, they have it a little bit different where you can send kind of a pre-suit financial affidavit, or every few years you have to update your finances. The only exception to that in Florida would be if your marital settlement agreement stated that you agreed, and the only way to do this would be by agreement, that you agreed to fill out a financial affidavit upon request.
Okay.
I'm going to assume that's probably not the case here. They're probably just sending you one and saying, hey, will you fill this out for disclosure purposes? Let's see if we can work something out before going to court.
Gotcha.
Now, as far as the inheritance is concerned, typically, first of all, an inheritance is going to be non-marital. So I know they're already divorced, but even if you were to receive the inheritance during the marriage, as long as you put that money into a separate account with only your name on it, don't put it into an account with both names on it, don't pass it through an account with both names on it, keep it completely separate. That is non-marital money, is not part of the marital estate.
Gotcha.
Now, even though he received that after the divorce here, typically that's not going to lead to increasing alimony. It's very hard to actually increase the amount of alimony after the divorce has been done, unless there's a situation where sometimes we'll do a case where maybe one party's unemployed during that period of time, so they do $1 per month of alimony as a placeholder until that person kind of gets back on their feet and starts making money again, and then they can start paying alimony.
Okay.
That's kind of the only exception to that. But assuming that's not the case here, typically the inheritance is not going to increase your monthly revenue to where you would then be paying more money in alimony on a monthly basis. However, he did say one thing in there about owing back alimony.
Aha.
And so if there is a substantial amount of back alimony owed, or really any amount of back alimony owed, they could come after you to pay that out of the inheritance money that you received. They can really come after you to pay it out of any asset that you have.
If you've got it, they're going to find it and they're going to want it?
Exactly. If you can touch it, they're going to want that money to pay back the alimony. So, it sounds like there were some agreements kind of done on the side here, orally, not in writing. Never a good idea to do it that way. Anytime you're dealing with alimony, especially when it's going through the court, you want it in writing, you want it filed with the court. So there's a lot to unpack here. There's some stuff that we don't really know all the details about, certainly. I'm not sure why he's behind on alimony. If, we've talked about this before, if he lost his job, if his income went down, whatever it may be, you want to go ahead and file a petition for modification right away, because typically the courts can't go back to any date prior to when you filed that petition. They can retroactively modify it from the date you file. So if you file today and you get seen in court 6 months from today, the judge can say, all right, I'm going to retroactively reduce your alimony back to the date you filed this petition 6 months ago, and you're not going to owe that amount any further. As far as this guy's case, if he hasn't done that, he's just going to continue to accrue money that he owes her, essentially, that is owed as back alimony, until he does that.
Sooner the better.
The sooner the better, yeah. Now, we'd want to take a look at the underlying divorce documents here, the final judgment or the marital settlement agreement, see what's going on. But if there's a legitimate basis to modify the alimony, and that's why you're behind, you want to go ahead and modify it. If you're just choosing not to pay it, that's not going to end real well for you. And certainly they're probably going to come after you for that inheritance money to get you caught back up.
Is not paying alimony, avoiding that, is that arrestable?
Eventually. So what can eventually happen is if you're willfully not paying alimony, if you're just choosing not to pay it, at some point the court can basically say, I'm going to put you in jail until you pay your alimony. It's kind of the one form of debtor's prison, but I'm going to give you the keys to the debtor's prison.
Gotcha.
So they're basically going to say, okay, how much money do you have in your account? Let's say, based on this guy's inheritance, you got 10 grand from this inheritance, you owe $20,000 in alimony. So you don't want to pay the alimony? Not a problem. I'm going to go ahead and put you in jail, and you can get out of jail anytime you'd like. You just have to pay that $10,000 that you have in your account. You have to pay that to the other side as alimony. That's your keys to get out of jail. And it's amazing how quickly people pay alimony when they sit in a jail cell for a few minutes, frankly.
Can you take a check right now?
Right.
Can I PayPal that over to you? All right.
Now, typically, the court doesn't like to do that. It typically is a long process to get there.
Right.
But ultimately, if someone's willfully refusing to pay alimony, that's what happens. Now,
that's what I was wondering, because I've seen mugshots or whatever, and it says alimony, forfeit, or whatever it is, and I'm like, wow, you can go to jail for not paying your bills. I mean, listen, if you owe it, pay it. It's plain and simple, but
Yeah, I mean, I've never met anyone who likes paying alimony. Let's put it that way.
Or doing jail time.
Well, that too.
It's
That
like
too.
way out the pros and cons there. All right. Next question is, I recently got hurt at work and I'm on light duty at the moment. Is my position protected? They said they moved me to a different department. I was told temporarily while being on light duty, but just 2 days ago, one of the people acted as if he was switching me permanently. One of the supervisors, which means that means a pay decrease and lose my position, all because I was hurt. Are they covered?
Well, that would kind of fall under workers' comp, which we've had Wayne Bilski on the show before, who does a lot of workers' comp cases. My understanding of workers' comp is fairly minimal, but basically if you're hurt on the job, they're supposed to try to find you a similar position at the same pay rate, is my understanding, that you'd be able to do with whatever the injury is. So here I'm assuming that the injury was on the job. I'm assuming that they put you on this other position because your injury doesn't allow you to do what you were doing before. Now, the question, of course, becomes, is your injury temporary or permanent? Are you going to get better from it and be able to do your other job again? Now, the one thing I do have a question about, I'm not quite sure on, to be honest with you, is whether they can give you a job that pays less or not. Now, my inclination would be is that they would have to try to keep you at the same level of pay because, just from a public policy standpoint, I would think that you wouldn't want people who get injured on the job being punished by basically saying, okay, we're going to keep you employed, but now you're down to minimum wage when you were making $80,000 before, or whatever it was. Because that's basically, forcing them to be unemployed, essentially, or in some degree, or finding new employment, rather. So I would guess that would probably be the answer just from a public policy standpoint. But again, you're going to want to consult with a workers' compensation attorney. If you give the office a call, I can put you in touch with Wayne Bilski, and he would be much more knowledgeable on those questions there.
Perfect. All right. Next one is quick question. I purchased a home and put earnest money down, and 6 days later, my daughter was left homeless with 2 kids because her fiance left and went back to Vegas. So they're with me now, and I just figured they're going to be with me for quite some time. So I had to withdraw out of purchasing that home to get something bigger. They don't want to give me any of my earnest money back, and I was willing to ask for half and give them half. They want to take me to court. Do I have any rights whatsoever? If not, I'm just going to drop it. But if I do, I'd like to know if I have any chance of getting half of my money back. Any advice you can give would be appreciated.
So this is a situation where all of your rights and, frankly, your responsibilities are going to be defined by the contract you signed when you put that offer in on the home. So typically there's going to be an earnest money provision in that contract. It's going to state, the amount of earnest money that you're paying, when it's due, and if there's any period of time where that was refundable. There's also going to state, possibly reasons for cancellation and timeframes for cancellation of the contract, whether it's an inspection provision, an appraisal provision, a financing provision. So you have to look at the entire contract that you entered into to see if there's a way to get your money back on this or whether you forfeited it by backing out of the contract.
But it'll be pretty much plain as day in that paragraph or wherever it is.
Well, it's plain as day to me. Sometimes, depending on what contract they're using. I mean, there is a standard, FLAR bar real estate contract that's out there. But I've also seen people use all sorts of wacky contracts when entering into real estate that I don't know where they got them from. So, read it through, see if you understand it there, if it tells you. If it doesn't, bring it to us or to an attorney and sit down, have a consultation. And so that way you can at least learn your rights and learn whether this money may be refundable or not. I think you're taking the right approach to it, and you're basically saying, do I have any rights here? You don't want to throw good money after bad, chasing something that you're probably never going to get back. But again, that'll all be defined based on the contract that's in front of you.
This might be a dumb question, but is earnest money, what is it? Is that basically the same thing as like a down payment, a deposit? Is that similar?
Yeah, it's similar. It's when you're purchasing a home, basically. You put down earnest money to show that you're serious about the contract.
Okay.
So, typically the more earnest money you put down, sometimes the more serious you are, because you could lose that money if you don't go through with the contract is kind of the idea.
Is that the same thing as like putting it in an escrow? We're going to put this in a 10 grow. Okay. Same
it
thing.
typically doesn't go directly to the seller. It gets put into escrow with the title company.
Gotcha.
And then of course, if there's a dispute like this, the title company has to kind of figure it out. And sometimes they'll just say, or a lot of times they'll say, well, until we get a court order and agreement, we're not doing anything, because they don't want any liability on their hands. So
yeah, I mean, poor guy's trying to do the right thing, house his kid and his grandkids or whatever. But I also get it too. I mean, offer you keep half, I'll keep half. You would think that would be okay, but apparently not. All right, we got about 3 minutes left here. Let me see if I can get to this one pretty quickly. I'm making a YouTube video talking about what my ex did to me in our relationship. I'm not using his name. Can I get sued? Could I be sued for defamation of character or anything like that, even though I'm not specifically saying his name?
Well, first, I always say this is America. You can sue anybody for any reason. So you're always opening yourself up to potential liability. Now, a defense certainly would be that the person is not identifiable. However, if I'm on the other side of that case, I'm going to argue, well, based on who you are and anybody in your circle of friends or family member who knows you, knows who you're speaking about.
Right.
Now, of course, the truth is always a defense to slander or defamation. So if what you're saying is 100% true and you can prove it, that's always going to be a defense to any sort of allegation that the other side may have. Of course, the dispute becomes whether what you are saying is true or not. And we've seen that many times. So the question really becomes is, if you're concerned about that, are you willing to fight it? If you really want to put that out there, you just have to know that that's a risk and weigh that risk when you're making these decisions as far as putting those videos out there online for the world to see. And as we know, once they're out there, they're very difficult to take down. Right. So, from a damages perspective, if the other side proves that it's false and wins on the slander or defamation, once it's out there, they could argue that prohibited them from getting jobs ever again. That somebody else reposted it and did identify their name, even though you didn't identify their name in the original video. So there's all sorts of different avenues that these cases can take and have taken, with the internet being out there and the way that the internet's progressed, obviously. So it's something certainly to be concerned about. And, the other side would be, why do you want to put this information out there? Why is it important to you? What is in that? Is it just lethargic to get it out there? But whatever you're saying, I would be very cautious to make sure that's the absolute truth. There is a difference between truth and your opinion on things as well.
Sure.
And if it's defamatory, if your opinion's defamatory, you could be facing a lawsuit. There may be very good defenses to that. Don't get me wrong. I'm not saying that they're going to win the lawsuit if it's your opinion, but just know that those can be ugly, ugly battles too that drag out in the courts.
If you got to ask, you think twice. I mean, that's just, again, that's my personal opinion. If you got to ask, can I get sued for this? Maybe you might want to reconsider. All right, we got our Mo Pro Tip of the Week coming up in just a few minutes. Plus, we'll get to another couple of your questions coming up in just a few. Send them on in, ask@DeWittLaw.com. If we don't get to it today, we can get to it next week, ask@DeWittLaw.com. Or you can also call the office if it's something you don't necessarily want to talk about on the radio, but you do need some legal advice. The number into the office is 1-800-DeWitt-Law, or you can also go to DeWittLaw.com. You are listening to the DeWitt Law Review on 107.3 FM and AM 580, Orlando's News and Talk.
Someone ran a stop sign about 50 miles an hour and hit my truck basically head on, and it caused a lot of damage to the vehicle, but also hurt me as well. The insurance company reached out like, hey, we'll make this all go away if you just, sign this and take this money. And even though that was my first accident, I knew that that wasn't the way it should have went. And that's when I decided to call Mo.
So after the accident, the insurance company approached Mark and tried to give him $1,000 to waive all rights to bring a claim. Fortunately, he was suspicious and knew better.
So it was no, if you have a question, just call me at my office or email me here. And I really enjoyed that.
Ultimately, in this case, we were able to recover $110,000 from Mark's injuries.
He's funny, he's approachable, but he also knows what he's doing. And if I knew anyone who's injured and needed a lawyer, I would definitely recommend DeWitt Law Firm. If you're injured on the go, just call Mo.
Mark's a great guy, and I'm so happy that we were able to help him with his accident case.
Welcome back to the DeWitt Law Review on 107.3 FM and AM 580, Orlando's News and Talk. My name is Jay Edwards here with Mo DeWitt of the DeWitt Law Firm, taking your questions, giving you some legal advice. You can send those to ask@DeWittLaw.com. That's ask@DeWittLaw.com. Or you can also call and leave a voicemail, 407 53 Moses. Let's go ahead and get to another question here real quick, Mo, and then we'll get to our Mo Pro tip of the week. Can we change my 10-year-old's last name without the father being involved at all? My daughter's 10. I gave her father's name at birth. He has never been in her life. He's also not on the birth certificate. She wants to change her last name to mine, so I wasn't sure if we could do that without getting dad involved at all.
So typically, in order to do that, you're going to have to give the father notice of some kind. You could try to do a disestablishment of paternity action if he's never been involved. That would probably argue that he has abandoned the child, essentially.
Okay.
And then you can move to change the last name. But typically with any of those kinds of proceedings, the court wants to give the father notice. They want to give him actual notice. If they choose not to show up, that's one thing. But yeah, you're typically going to have to give him notice one way or another in order to move forward with any sort of name change or disestablishment of paternity action.
And then if there's no response or anything on his end, then you can move forward a little bit more easily?
Yeah, once he's properly served and noticed, if he chooses not to participate, then of course you can move forward and have a court move forward and sign off on that. But, a lot of times... depends on what side of these situations you're on, honestly. But, one side says, oh, dad's never been involved. Then dad shows up. He goes, what are you talking about? I was on a work trip for the last month. I'm here all the time.
Right.
I've just seen every different facet of the story. I'm not saying that's what's going on here, but that's why the court is so concerned with notice. They don't want to take away somebody's rights or change a child's name, take away the last name of a minor child. Without giving the other parent notice and the opportunity to be heard on that. If it is a situation where dad has truly never been around, then yeah, you can move forward, but you do have to properly serve them, provide them notice. The court's going to check that and make sure that they were provided notice. And then, of course, if they choose not to participate, which in my mind, if they never participate in the child's life, why would you show up to court? But again, I've seen that happen before too. I've seen the situation where dad's literally never been around and shows up to court and goes, I don't know. I got these documents to be here, so I showed up.
Here I am.
Yeah, and ultimately he's not real concerned about it, but he shows up anyways. So, yeah, you have to give notice, and that is the reason for it. Is they want even if dad's never been involved, they want to make sure that he has the opportunity to be heard in front of the court if he wants to.
Perfect. All right, let's get to our Mo Pro tip of the week. We got a couple minutes. What do you have for us?
So I'm going to go a little bit of a different route this week than normal, but I want everyone to be watching this legislation that's going on in the Florida legislature right now. It's House Bill 837. I think we're going to do a whole show on this maybe next week or the week after. But it's some pretty scary legislation, in my opinion. They did the property insurance reforms before. We talked about that. I try to be very candid and straightforward with people. I basically said, look, yeah, we needed some property insurance reform in the state of Florida. I wish they had a provision in there that guaranteed rates go lower, but that passed. Now they're basically trying to do this with the same kind of tort reform, insurance reform, with basically all lawsuits, all injury lawsuits. And I think really all the listeners need to know this is bad legislation is that they're trying to remove what we call bad faith. And bad faith comes from common law. It came from our English common law. It's adopted as part of that. It's not written in the statute, but all it basically says is when you're negotiating in court, when you're acting in court to settle a case, you have to operate not in bad faith.
Okay.
The insurance companies are trying to remove that because they don't want the consequences if they act in bad faith.
Oh.
So, why on earth you would ever pass legislation that allows one party to act in bad faith is beyond me.
Right.
There's many other things in here that are just really horrible for consumers. They're saying that this bill is, for small businesses in Florida. Unless Geico is now a small business in Florida, I don't know who this really benefits.
Right.
But we'll go into the details, more about it later on. But it's House Bill 837. Go read about it. It's pretty bad legislation for anybody living in Florida, in my opinion.
All right. Worth getting in a whole show over. So I love that. All right. Very good. We will check that out, and we'll swing back to that topic coming up here in the next week or two for sure. You have been listening to the DeWitt Law Review right here on 107.3 FM and AM 580, Orlando's News and Talk. To reach out to Mo DeWitt and his team of the DeWitt Law Firm, you can check them out online, DeWittLaw.com, or the number to the office is 1-800-DeWitt-LAW. You're listening to the DeWitt Law Review on 107.3 FM and AM 580, Orlando's News and Talk.
the military background, we like to help. And if we see somebody in the need, we'll stop and do what it takes to help. I was on the road driving and I saw a car accident. And I stopped to see if everyone was okay. And in the midst of that helping, there was another incoming vehicle. And the vehicle hit me pretty good. And it shook me pretty good. Right after the crash, I seen a lot of things going wrong with accidents and people not being taken care of. So I searched for you guys for the DeWitt law firm. First of all, this was in the middle of the night, and I was able to get a hold of someone, which I didn't know that there was going to be someone up that late at night. You guys do everything, and it was very, very stress-free situation. So if I had a friend with a situation like I did, I would definitely recommend the DeWitt law firm because I know they will be taken care of. If you're injured on the go, just call Mo.